Thanks, Dan. Hi, everybody. Thanks for joining us today. Just our quick standard disclaimer. This presentation is for educational purposes only. It's not legal advice and does not create an attorney-client relationship. We'll have some specific information at the end on contacting us if you have some questions. Also, so that you can get on with your day. We'll move through this information rather quickly, which is the point of these weekly sessions. We want to get you some good, useful information and then let you get on with your day. So thank you, and we appreciate that. So let's start out with a general overview. Retaliation, what is it? So in general, just out in the world, retaliation is doing someone harm in return for actual perceived injuries or wrongs. That's, pretty basic. Everybody's heard of it. Everybody's thought of it just in life in general. In the employment law context, however, it's got a little bit more of a specific classification to it. So with employment law and retaliation, it would be defined as an adverse employment action taken because an employee has engaged in a legally protected activity. That's kind of the important part of it, is that meaning an employer does something negative to an employee after that employee has engaged in some sort of legally protected activity, and we'll discuss this a little bit more in detail as we go through. That is really going to be kind of a big focus, is the legally protected activity. So the elements of a retaliation claim when we're speaking within, again, the context of employment and context of the legally protected activity. So number one, the employee has to undertake some sort of protected activity. Number two, a material adverse action is taken by an employer. And number three, there is a connection, a causal connection between the protected activity and the materially adverse action. I'm going to give kind of a case study in a little bit here, but protected activity by an employee could be something like complaining about work conditions, complaining about something they feel violates the law. That could be an example of something that's protected for an employee. And then as a result of that protected activity, say somebody complains about working conditions, they're fired because of the complaint, that would be a material adverse action, and that would be a causal connection between the two. So let's explain a little bit further with this one. Again, this is entitled The Forgotten Claim because this one is always sort of lurking out there in addition to the other normal claims that we think about. So an employee experiences a material adverse employment action as a result of their engaging in protected conduct. So protected conduct, again, we started to talk about this. This is a little bit more detail. They complained about something that's prohibited by law. So if they complained about, hey, this employee is discriminating against another employee, the employer then fires them as a result of that complaint, that would be an example of conduct prohibited by law. So something along those lines, or, as noted, harassment, financial wrongdoing. The employee requested a claim benefit protected by the law. So that would be, they get hurt at work, they want to file a work comp claim. An employee wants to use paid leave that's offered under city ordinance or state law. Use of FMLA if they have a disability and they want a reasonable accommodation. Another area where retaliation can occur is if an employee took part in an investigation involving claims of discrimination or retaliation. So if an employee was interviewed by either internally or by an outside agency regarding some sort of workplace investigation, and then the employer later disciplined or terminated them for participating in the investigation, that could be considered retaliation. And then importantly, especially these days, the employee engaged in concerted protected workplace activity under the FLSA. That generally relates to union organizing activity, discussions about union organizing activity, or complaining about their terms and conditions of employment. All that stuff is protected by law, and an employer can't take a negative action against an employee for engaging in protected activities, or they risk getting hit with a retaliation claim. Let's get into what material adverse means. So material adverse would be an employment action that one might see as deterring a reasonable person, meaning an employee, from engaging in protected activity. So again, you have done one of the things on the previous slide where you complained or you did something that's protected by law, and then the employer takes a materially adverse action based on that, specifically based on that. So then you've got the causation and the materially adverse action. So things would be denial of a promotion, denial of your job benefits, demoting the employee, disciplining them, reprimanding them, a transfer, suddenly lower performance evaluations, and then up to and including terminating someone from employment. So here's the case study, or here's a real life example of a retaliation claim as it came up in a workplace. So I know someone who works for a large federal government agency. A few years back, she complained about a sports team name, a logo, and a mascot. The images of the sports team name, logo, and mascot were all over the office. People were wearing them on jerseys. They were just very in favor of this sports team and their logo. This employee that I know, she felt that the sports team name and logo were racially discriminatory against her, and also she felt that having all that stuff around her based on her background created a hostile work environment. So this person filed a claim with the EEOC, the Federal Equal Employment Opportunity Commission. The EEOC came in and investigated her claims of, again, racial discrimination, harassment, hostile work environment based on the sports team logo. Her claims for discrimination based on race and a hostile work environment were dismissed. The agency, the EEOC, found she did not have a leg to stand on with those claims from the coworkers wearing the logo, talking about the sports team, all those sorts of things. However, she did have a retaliation claim that she made as well, and that claim was found to be valid. Why did she succeed on this retaliation claim? The employer, after she made her complaint, had transferred her to a different position, reportedly to shield her, quote unquote, from interactions with those other workers and their sports gear, the logo displays, and all that. The new job that she was transferred to so she could be shielded even had the same pay and benefits as her previous job. So no loss of money, no loss of position, just moved to a different area. But the EEOC found that the transfer was retaliatory because it determined she was transferred as a result of her making a complaint. Again, that's protected activity where you're complaining about something in the workplace, and she was transferred as a result of her complaint. So her discrimination and harassment claims went away, not valid, no merit, but the fact that the employer transferred her to try to protect her ended up in a valid retaliation claim, and she got a payout. So that's just an example of how retaliation can work its way into these different situations and turn into a claim. So why is retaliation the forgotten claim, as we have titled with this webinar? Well, as we were just sort of discussing, most employers focus on other claims instead. They look at the protected class discrimination. They look at the hostile work environment claim. They look at wage and hour issues, or they look at leave issues, whether that be FMLA or city paid sick leave, state paid sick leave. The issue comes in that if you're focused on all of those claims, which are very good things to be concerned about, you also have to be very careful as an employer to not take steps that could, in addition to those claims listed above, could trigger a retaliation claim as well, because not only could, for example, the person say I was harassed based on my age, religion, disability, race, something like that, they could also make a retaliation claim as well if they said, with that harassment, I also suffered an additional workplace adverse action based on my activity or my classification. One of the scary things about retaliation is, even though it is the forgotten claim, it's also the most commonly filed claim with the EEOC. People would probably, including myself, until I started looking into this information, I would think, oh, it's always going to be discrimination. It's always going to be harassment. No, the most frequently filed claim is retaliation. So for example, as seen on the slide, fiscal year 2021, the EEOC reported that 56% of its filings included retaliation claims. They're often piggybacked, as we were just discussing, onto other EEOC claims, such as protected class discrimination, some sort of harassment, things along those lines. Retaliation claims can also be added on to if an employee has made a claim about wages, so a wage and hour issue, or if there's something regarding leave, as we were discussing earlier, some sort of protected leave, and they feel there's been a adverse action as a result of their complaint, that too could add a retaliation claim to a broader package of grievances or filings an employee could try to make against an employer. So why is this such a big problem? The main reason is it can be extremely expensive. In addition to direct damages, employees can also petition for lost pay, lost benefits like a 401k contribution, emotional pain and suffering, punitive damages, and attorney's fees. So in addition to the base level of monetary damages that may be claimed, there's all these additional factors that can be added into the claim as well. So a retaliation claim can get expensive very quickly. So as an employer, what can be done to avoid retaliation claims? Well, there's a few steps, and we're going to go through them because this is critically important for any employers out there who want to be aware of this issue, number one, and then get ahead of it and avoid it, number two. So first, written policies and procedures. Every employer should have written policies and procedures in their employee handbook that prohibits discrimination and harassment in the workplace, and also have discussions on having a safe and fair company culture. In addition to those anti-harassment and anti-discrimination policies, employers should also have written anti-retaliation policies that informs employees of the types of actions that can be considered retaliation, as we were discussing earlier, as well as how to report and who to report any retaliation issues to within a company. Second, an employer wants to have training regarding retaliation, so make sure all supervisors, managers, and HR staff, most critically, and then also all other employees, are trained on your anti-retaliation policy, and make sure that they are emphasizing the company's commitment to protect workers from retaliation. Again, you want to explain the legal risk to these decision makers, your supervisors, managers, HR staff, and of course you want to have that information to the employees as well. But you really want to hit it with your decision makers and supervisors, how difficult it can be for an organization when it gets hit with a retaliation claim along the lines of, none of you folks may have a job anymore if we get sunk by a retaliation claim. An employer wants to have a reporting process in place, so inform employees of who to report retaliation to, when to do it. Generally, it needs to be reported immediately. Have more than one reporting mechanism if possible. Some of the language that we include for our clients in the employee handbooks that we prepare is, if you've got an issue with the person you're supposed to report to, we would have some workaround language of how to get to another person. That's always important. An employer also wants to have a thorough investigation procedure. If there's a retaliation claim, you want to investigate promptly, document the who, what, where, when, why, and how of the incident. Inform the complaining employee as well as those participating in the investigation that the retaliation will not be tolerated in any form, and that includes actions related to participating in an investigation. And employees, or make sure also that your policies, again, as we were discussing, require that employees report any retaliation. And then finally, you want to be able to take corrective measures if needed. If you do your investigation promptly, you find retaliation has occurred, you want to jump on that right away with corrective action, whether that be counseling, write-up, suspension, termination, anything in between, along those lines where you're getting out in front of it and handling it as promptly as possible. You also want to be consistent with how retaliation investigations are handled, and if discipline is required, how discipline is hired as well. So consistency is important in the process too, to make sure that a company is not getting out of its lane in terms of treating people differently. As noted, we were going to go through the information fairly quickly, but I think that this is useful and this is important, and this is a topic, again, that people need to just be aware of. It's lurking out there too with your other concerns. And remember, as we always say, compliance is not optional. Please reach out to us if you have questions for our clients. If you are interested in becoming a client, our contact information is here. Thank you, everyone, for participating today, and we look forward to speaking with you again in the near future. Have a great rest of your day.